Hello friends, hope you are doing well. So in today's video, I am showing you how to draft an appeal submission against a penalty order under section 271(1)(b). If you can remember, in one of my previous videos, I have at length discussed provision of section 271(b) and its consequences. I have also shown you how to draft reply against SCN proposing this penalty. So basically this penalty is levied when SSC fails to furnish the details called via notices issued under section 142(1) during the assessment proceedings. The penalty is straightaway levied at the rate 10,000 for each failure. Now this penalty from AY 1718 onwards is replaced by section 272A subsection 1 clause D. The quantum is same 10,000 for each failure. So in this case SSC had already been served with the penalty order. Penalty had already been levied and SSC has preferred appeal to the CIT appeal, of course faceless. And now we are making the submission for the penalty. So let's see. Before the Honorable Commissioner of Income Tax Appeals, NFAC, National Faceless Appellate Center. Here I have mentioned the order. This was a case of pre-assessment of 1011 against which penalty was levied. Written submission, may it please your honor. So I always emphasize since this is a faceless appeal. So before going into grounds of appeal, always mention facts of the case in the very beginning of the submission. We don't know whether appellate authority have form 35 in his hands while he is going through our submission or not. So it is always preferred to mention brief facts of the case before beginning of the your submission. So in this case, actually, order was passed under section 144, that is ex parte order, and SSC never received so-called notices 142(1) issued. So SSC was not given any opportunity of being heard, and penalty was straightway levied. So all that fact I have here mentioned. Appellant filed a return, so and so. This was the case. Then appellant has not received any of the notices or letters alleged as sent to her in impugned penalty order. The learned AO in impugned penalty order dated so and so levied penalty for alleged non-compliance of the defaults. Your appellant is in appeal against the aforesaid levy of penalty, which is the ground number 1 and only ground of this appeal. There is no other ground. In light of above background, we would like to make hereby detailed submission in support of ground of appeal on behalf of the appellant. So I am going through the ground number 1, which is the one and only ground of this appeal. On the facts and the circumstances of the appellant case and in law, since appellant has not received any of the notices or letters alleged as sent to her in impugned penalty order dated so and so, passed under section 271(1)(b) of the Act, the learned AO has erred in invoking provision of section 271(1)(b) and thereby levying penalty of 10,000 by passing order dated so and so under section 271(1)(b) of the Act, and hence impugned penalty order is bad in law and therefore be quashed. Friends, remember one thing. Whenever you mention ground of appeal in appellate submission, please mention it in a bold letters and also underline the same so that it can be easily distinguished from the remaining submission, and it also catches the attention of the appellate authority who goes through the submission, and it also gets easier for him to know the exact ground of appeal. So here only difference of the SSC is कि उसको ये जो अलग नोटिस है वो कभी मिली नहीं है. 142(1) में जो नोटिस इशू हुई है, as AO told, it was served on 15/9/2017, but she never received such notices. So let's see. Appellant is a senior citizen aged around 80 years. Appellant is unable to act upon herself for the tax matters and take guidance from her relatives. During the assessment, she has not personally received any letters or notices alleged as sent. She directly received the order under section 271(1)(b) around so and so date. Further, this assessment also got completed under section 144, that is ex parte. So she was never received an opportunity of being heard, and in assessment a huge addition of 1 CR was made. So कौन सैन माइंड का आदमी, कौन सैन माइंड का टैक्स पेयर होगा जो अपॉर्चुनिटी मिली हो और उसको यूटिलाइज नहीं करेगा अपना डिफेंस करने के लिए. So she never received this notice. She was not even knowing that this kind of assessment been going on in her case. So that is the second defense which I have taken here. In fact, the assessment order under section 144 also passed ex parte, that is under section 144. Why this order? A huge addition of approx 1 CR been made. If appellant would have received above notice, she would have made all the possible efforts to defend herself. Unfortunately, she was deprived from the opportunity of being heard, as no such notice as alleged received by her. With due respect, it is submitted that a person with a sane mind won't miss a chance of his or her defense when such enormous addition is being proposed, which may drag him or her into further litigation. Actually, SSC came to know about this whole assessment procedure only when her bank account got attached. Before that, she was not knowing that assessment already been completed and such huge demand wasn't raised. So, of course, afterwards she needed to file a separate 2 appeals, one for the quantum addition which been made and other for this penalty, which unnecessary cause her hardship considering her age. Now let's look at the section 271(1)(b). So power to levy penalty is discretionary and penalty cannot be levied merely because it is lawful to do so. No penalty could be levied for technical and venial breach of the provisions, and no penalty could be levied where the breach provision flowed from the bona fide belief of the SSE. If you look at the language of the section 271(1)(b), the word used is may. It means AO has discretionary power, and if SSE shows some bona fide belief or reasonable cause not to levy so, then AO can always forgive this penalty under section 273(b). So now let's see what 273(b) says. Penalty not to be imposed in certain cases. So basically 273(b) grants immunity from levying penalty in certain cases, notwithstanding anything contained in provision of clause B of subsection 1 of section 271, that is the subject matter of this appeal. And this remaining section, I want to get into each and every section. Let's read the no penalty shall be imposed on person or SSE as case may be for failure referred in the said provisions if the he proves that there was a reasonable cause for the said failure. मतलब SSE अगर प्रूव कर दे कि reasonable cause है तो AO can always grant immunity under this section by not levying penalty. Here, this section starts with non-obstance clause. It means it is overriding effect over these clauses. So that is the defense I have taken. Further, section 273(b), which start with non-obstant clause, clearly provides that penalty under section 271(b) need not to be imposed if it is proved that there was a reasonable cause for such failure. In case of appellant, it is already established that there was a reasonable cause for the SSE in failure to comply with the provision of section 271(1)(b) as non-appearance of the SSE before AO. It was the only cause of non-receipt of the notices. Non-compliance on account of non-receipt of notices by SSE could not be taken as intentional. जब SSE को नोटिस मिली ही नहीं है तो कैसे AO एक्सपेक्ट करे कि उसके सामने कुछ सबमिशन करे या अपियर हो. SSE को नोटिस मिले तब उसको पता चलेगा ना कि उसका असेसमेंट चल रहा है और उसको डिटेल्स प्रोड्यूस करनी हो. उसको नोटिस ही नहीं मिली है इस केस में तो. Hence, penalty levied under section 271(1)(b) is bad in law and needs to be deleted. After making law clear, please mention relevant case laws along with the citation. We would like to rely on following judicial rulings in support of our arguments. In case of Vamita Singh, ITAT जयपुर का एक डिसीजन है रिसेंट 2021 का. It was held that non-appearance of the SSE before the AO or non-compliance of the notices issued was only because of non-receipt of the notices by SSE and therefore the same was reasonable cause not to levy penalty. So SSE को यहाँ भी नोटिस नहीं मिली थी, तो एसएससी अपीयर कैसे होगा ईओ के सामने ड्यूरिंग द असेसमेंट? The above decision followed following rulings, where in identical cases it was held that non-receipt of notice is reasonable cause for non-appearance and no penalty can be levied. तो ये सारे केस में भी सेम रेशियो अप्लाई किया है। एसएससी को नोटिस नहीं मिली है तो वो अपीयर नहीं हुए हैं, तो ट्रिब्यूनल ने ये पेनल्टी को डिलीट कर दिया है। Last but not least, always mention final prayer at the end of the submission. In light of the above submission duly supported by the judicial precedents, it is prayed that the appellant's failure to comply with the notice is not deliberate as alleged, but due to the non-receipt of the notice, which was beyond her power. Considering this fact, along with the age of the appellant as well, it is prayed to read the impune penalty of 10,000 and oblige. Thanking your honor, yours truly. So always conclude your written submission with the final prayer to the appellate authority, wherein you pray to your honor for deleting impune addition or penalty as case may be, considering your written submission, which is duly supported by the judicial pronouncements. So that was the end of this video as well. Hope this video would help you in drafting written submission for the penalty. Thank you for watching. Have a good day.